Well, thank you all for coming today. I guess that's a Southern way to start a meeting, right, y'all, for coming today. So we appreciate your taking time out of what I'm sure is a busy schedule for a lot of you to come down here today and to listen and to share your thoughts with us. This is the Shared Parenting Study Committee, the House Shared Parenting Study Committee. I'm going to start by introducing some of our members today and the people who are sitting up here and busily taking notes and getting ready to ask some questions. But I'll start over here with our Representative Edward Lindsay. Representative Lindsay is Vice Chair of the House Judiciary Committee. Then we have Chairperson Judy Manning. Judy has the responsibility for the Children and Youth Committee in the House. I have responsibility as Chairman for the Motor Vehicles Committee. You may ask why I'm here. Well, you know, I asked the same question probably. But that's right. That's right. We're going to work in the shared parenting thing. We're going to work in a driving statute at the same time. So, you know, yeah, that's right. 21, I think, is what's going to be the legal age. Pushing it up.
After my children are my children will be loved.
Yeah, we'll make it in accord with when the insurance premiums go down. And then just arriving is Mark Butler. Welcome, Mark. And Mark is here. He's the Vice Chair of the State Institutions and Property Committee. That's, if you don't know what that means, that's the prisons that they manage, and that's where kids go that are the results of a bad situation here. So probably shouldn't make fun of that. But the fact of the matter is that Mark is joining us today. Thank you for coming from Carrollton here today. Appreciate that very much. The fringes of Alabama. That's probably something we shouldn't debate. Down here on my right is Mary Lewis, and Mary is sitting in for. Well, I'll say you're sitting in from the Speaker's office. How about that? That's pretty close to probably what you're doing. Jill Travis is from our Legislative Counsel's office. And thank you, Jill, for being here today. And then my erstwhile companion over here from House Research is Keith Williams. That's where everything you give us in terms of written testimony, that's where this all goes and resides. And then Keith gets the opportunity to digest it for us a little bit and then to help pass out the information that you've given. I would say, interestingly enough, that the testimony that received, the written testimony and other reports that have been ancillary to the written testimony probably make a pile of data like this. So Keith is getting his chiropractic back worked on here from handling all that stuff, and but it really is represents a lot of work for a lot of people that are sitting in this room today, and so we really do appreciate that, and that's exactly what the study committee is for, to try and gather as much information to determine if we need to change the laws regarding custody arrangements from a shared parenting standpoint, or whether we do not, and if we do, then how that would be done. By way of shutting off my cell phone here, I don't know where that came from. I'm sorry. I'm going to escape that. We'll call her back later. This is being web broadcast today, and if you have been here before, you can choose to take notes or not, but it will be available on the House website. And what is the address of that, Keith?
It's www.legis.state.ga.us, and there's a Member Services tab on there that you can go to get to the webcast.
Okay. And so I think the last two are up on that already, and so you'll have an opportunity to do that. So the cameras you see up here are doing the same thing today. So as you come forward to give testimony today, we'd appreciate you coming to the microphone over here at the podium and operating from that standpoint. With that, we are going to try to conclude today by 12:30. Some of our people have some appointments today, and we need to spend a little bit of time together as a committee in executive session just to see kind of where we are in terms of the process. So We're going to cut off testimony at 12:30 today, and we'll try to work as many people in. We have 8 people, 8 people who have signed up beforehand, and they're on the list. We've got about 2 hours and how do you work that out? About 2 hours and 45 minutes to do this. So if we could work at around 10 minutes of testimony and then some time for questions, that would be very good. We do have a sign-up sheet here, and I know some people called in late and requested an opportunity to testify today. If we will take a break as we go through here today, and I'll do that. We'll take a break, and if you have a desire to testify, please come and see me at that point in time. We really want testimony today that's narrowed to the subject of the custody issues that would be involved in shared parenting type of thing. We've had an enormous amount of testimony, a lot of it good testimony, some of it more anecdotally based than others. And though anecdotes are good, we would really try to stick to the issues regarding custody pretty articulately. And so with that, let me just read down the list of people that have signed up, and so you know what order you're in today. Charles Thorne, David Drake, Mark Howard, Clarence Taylor, Rick Leeds, Chris Woodham, Shelley Centerfit. Shelley, thank you. Yeah, you were here last time, I know. And Carl Johnson is on the list for today. Okay, so we'll start with Mr. Thorne. Would you approach the podium? Thank you.
Mr. Chairman, members of the committee, legislative staff, and ladies and gentlemen, my name is Stanley Charles Thorne. It is a great honor to be allowed to address this committee. I am a Texas resident, but I've been asked to speak on behalf of Georgia parents and children. My mission in life these days, starting about 5 years ago, is to change the way family law is done in America so that it is less destructive to parents and children. As you can see on paragraph 1 of the background information that I furnished the committee, I have recently started an organization called the American Family Justice Project. I am really fortunate to be working with some very world-class people who address the dimensions of marriage and divorce law in America, and it is commonly thought of as only having a legal dimension, but what we recognize when you take a broad-based look at divorce law in America is that it has historical, psychological, sociological, economic, legal, and ethical aspects. The purpose of the organization is stated there in paragraph 1. I won't take the committee's time by reading it, but I want to say that I speak here today primarily as a father of 3 children. My sons are 21 and 17. My daughter is 12. My resume is attached to give you a flavor of my employment history, but I did not come to constitutional law until about 5 years ago, and my background was commercial law, primarily energy law, real estate law, and court-ordered mediation law. I've been an attorney for 25 years. I'm now practicing a nationwide practice. I have about a half a dozen carefully selected cases around the country in both state and federal court challenging various aspects of family law in America on constitutional grounds. I can tell you that this system is enormously destructive in a needless way. I have a case in Florida in which I'm challenging the no-fault divorce statute there. I have cases in both state and federal court in Wisconsin in which I'm challenging no-fault divorce in Wisconsin. A case in Maryland on child support collection abuse. Likewise, a case in New York on child support collection abuse. And that case is actually, we've recently filed a petition for writ of certiorari to the U.S. Supreme Court on that case. What I'm trying to give you a sense of is that I have sort of a nationwide perspective, and I'm intent upon effecting change through the legal system. And I must tell this committee, I cannot imagine any more important work for you to do for the citizens of Georgia, Georgia parents and children, because nothing affects citizens more deeply and personally than family law. I want to give you a sense of the history of family law. I do want to mention in passing that there is a lot of energy. There's a tremendous rising tide of energy for change and reform in family law. Shared parenting legislation is on the ballot in North Dakota. That'll be voted on in another week or so. Michigan is seriously considering it. At the last committee hearing, I passed out the Oklahoma statute for shared parenting that's been on the books there for 10 years as an example of a very simple, very straightforward way to accomplish shared parenting if you choose to do so. On September 14th, I was fortunate to be in New York City to hear the symposium for the Institute of American Values. Their focus was on family law reform, and your Chief Justice of the Georgia Supreme Court, Leah Sears, was there as a speaker, as well as Chief Justice of the South Carolina Supreme Court, the Honorable Jennifer Toll. I can tell you that jurists and legislators around this country are seriously trying to get a grip on what's wrong with family law, and that people all over the country are realizing, although they may not be able to articulate it very well, that there's something tragically amiss in our family law system. My mission in life is to try to change that through legislative initiatives, and that's why I'm so thankful for this committee's work, and I commend you for taking this task up. If you'll turn to the last page of that biographical material, I want to give you an example of what happens in family law, and then I'll give you a quick history that'll help put it in context. I have a case pending in Illinois right now that is not uncommon. Unfortunately, it's all too typical. It was a husband and wife divorce action involving 6 minor children. It took 6 years to get a final custody order in that case, and that couple spent over $500,000. Instead of those children having a good college education or the seed money to start a business or something of that nature, that money has been dissipated primarily to attorneys and expert witnesses and so forth. It took 2.5 years to get a temporary custody order, the first custody order. It took 6 years to get the final custody order. The reason that happens is illustrated by this last page, and if you just bear with me and follow along, I illustrate this with an example. P1 is parent 1, P2 is parent 2, C1 is a child. When courts all over this country, including Georgia courts, consider divorce, they basically address 3 issues. Whether or not the marriage is going to survive, and with no-fault divorce, there is no issue there. Every no-fault divorce case that starts ends in a divorce. That's one of the reasons it's facially unconstitutional, because the only divorce case that ever ends without a divorce is the case that is dropped by the party that started it. My research shows that about 15% of Texas cases end in what's called a non-suit, which means that about 15% decide that the divorce is not what they want to do. The remaining 85% all end in divorce. If you will draw an oval around P1 and P2 under number 1, marriage termination, and draw an arrow between the two, I want to emphasize that what happens in the marriage termination context when it's done constitutionally all stems from issues that are out of the relational nexus between spouses. The same thing happens if you drop down to property and do an oval around P1 and P2 under assets. When the court moves from the divorce decision, which is a foregone conclusion under no fault, to the property issues, they divide the assets and the liabilities. And in both of those circumstances, it is issues determined based on the relational nexus between the parents as spouses. What happens with custody adjudication is an error in judgment by most judges, and if you take the same oval and put around P1 and P2 under number 3, child, most judges, when they reach the adjudication of child custody, treat the parents as though they're dividing one set of parental rights, just like they're dividing one set of property, assets, and liabilities. That is a fundamental error in judgment which is fed by the custodial, non-custodial model of child custody, and it is a huge error in judgment. If you drop down to the second example, what I want to illustrate, if you'll draw an oval around P1 and C1, the relational nexus between parent and child is individual to each parent and child. And so you have one set of parental rights between P1 and C1. Okay? You have a completely different set of parental rights if you'll draw an oval from P2 to C1. I cannot overstate how important it is to understand that custodial, non-custodial model of custody adjudication is fed by this misunderstanding that each parent is sharing a common set of parental rights, and it's not the case. One of the reasons that I'm arguing in federal court and state court in both Illinois, and in this case it'll be happening in Florida, that's already starting at the trial level, is that as a simple matter of equal protection of the laws, there is a constitutional imperative for each parent to be treated equally before the bar of justice. When I look at the Oklahoma model of shared parenting legislation, the legal presumption for shared parenting that's in the Oklahoma statute is a simple reflection of one of the most fundamental aspects of American jurisprudence, that if you have two citizens before the bar of justice and they are equally situated, that they deserve and in fact are entitled under our system to be treated equally. Now, when you have the misunderstanding, as many people do, that the parents are sharing a common set of parental rights, then logically the mind can go with a determination that you've got to divide that up and you've got to somehow accommodate both parents, but it makes sense to give parents disparate treatment in the time they have, who pays for the child support, and all that sort of thing. All of that is logically inconsistent with the fact that each parent has their own unique parent-child relationship, and that as a matter of equal protection, they are entitled to be treated by the law as equals. That is consistent with a legal presumption of equal parenting. So I offered the Oklahoma model not as the best, but as a very simple, straightforward way for the Georgia legislature to accomplish what I believe is completely consistent with the constitutional mandate in both the 14th Amendment of the U.S. Constitution, and I'm certain the Georgia Constitution, for citizens to be given equal protection of the laws. I want to give you a quick history so that you can appreciate how we got where we are today. In the early days of this country, we had almost no divorce. Divorces were only granted legislatively in the 1700s when this country was founded in the early 1800s. That began to change to where some states began to allow judicial divorce. When divorce happened, it was almost universally father custody. And because divorce was fault-based, father custody being nearly universal meant that there were almost no contested divorce cases, and when they were, dad got custody and mom got nothing. As the 1800s went on, a couple of things started happening. A tender years doctrine began to take hold, where children of tender years were given, custody was given to mom. And as the 1800s went on, mom got custody more and more often. And at the same time, there was a concept that started in the courts of Europe called no-fault divorce. It was rejected conceptually in the courts of Europe. It came over to America. It was rejected here. It bounced back to Europe. And around the turn of the century, in the early 1900s, the revolutionary spirit that was going on in Europe, revolutionaries, Marx, Engels, an Italian philosopher named Gramsci, all decided that whenever they were able to accomplish revolution, that the best way for the state to become the controlling, normative communicator of values was to undermine the church and the state. They recognized that if they could undermine, church and family. They recognized that if they could undermine the church and undermine the family, that the state would fill that power vacuum or that void, and that the state would transfer values from generation to generation. When the Russian revolutionaries in 1917 took control, they immediately established no-fault divorce. It was an astounding success. It was so successful beyond their wildest expectations at undermining both the church and the family that they abandoned it 35 years later because it was killing the soul of Mother Russia. It was so destructive to the soul of the Russian people that they backed away from it. And as a totalitarian government system, they could do so very quickly. In the 50s, it's very ironic that as Russia was backing away from no-fault divorce, a process was happening in America where no-fault divorce was being considered. A nationwide organization called the National Council of Commissioners on Uniform State Laws began to consider no-fault divorce. I've furnished the committee with the outstanding historical research by a Wisconsin woman named Judy Perico. She's already written a book called Stolen Vows about no-fault, and she spent the last 5 years or so in some incredibly deep historical research into the history of no-fault. The first of 3 parts of her work has been furnished in the red-covered manual that I've offered the committee. What happened is Russia was abandoning no-fault divorce.
I'm going to ask you you're going to run out of time here.
Okay.
I understand you're going through your historical perspective, and that obviously is valuable. It's covered in the material you've given to us.
Well,
I'd ask you to attempt to focus on those points dealing with the custody issues that we're focused on now.
Let me just say that no-fault started to sweep the nation in the early 70s. We went from 300,000 divorces a year to about 900,000 to 1 million in America today. Child custody law changed because when no-fault took big, expensive, long-running divorce actions away from the issue about termination of the marriage relationship, you had a lot of highly capable matrimonial lawyers who just shifted the big, expensive, long battles to the custody arena. Child custody weaponizes children. If you treat each parent as an equal, you defuse what is a battle to the death that almost every parent is going to fight, because the custodial, non-custodial model means that one parent is going to be a winner in their perception, one parent is going to be a huge loser. The loser parent is going to be marginalized. Almost every parent that cares very much about their children at all is going to fight that with everything they've got. In fact, the custodial, non-custodial model rewards troublemaking, because in most states, if the parents can't get along about custody issues, the default goes to the custodial, non-custodial model. If you do shared parenting, you diffuse a lot of that, because the status quo before the divorce action, which I refer to as the status quo ante, parents generally are accommodating, they're flexible. How are we going to get the kids to school? How are we going to pay for the braces? All those parental issues are generally accommodated, they're flexible, they're more or less forgiving, because they work it out for the best interest of the child. The custodial, non-custodial model psychologically goes against that. It actually invites controversy and disputes. It exacerbates the difficult tensions that are already there in a divorce action anyway, but parents are not divorcing their children. And what the custodial, non-custodial model does is pits parent against parent in a way that they have no choice but to fight, because they know that if they don't win custody, if they don't have sole custody or controlling custody, they're going to be so marginalized from their child's life that they're unwilling to accept that. And like the Illinois case that I have, I could go, if I started compiling a list of all the people who spent every penny they had in a custody battle because they will not accept losing their parent-child relationship. If you go with shared parenting, you diffuse much of that. If you couple it with a tight requirement for a parenting plan, you'll take about half of all custody cases out of the system. When I heard your Chief Justice Sears in New York, she mentioned in passing that when she did a study of all the caseloads in Georgia, about 65% of all cases, both civil courts and criminal courts, come from domestic relations issues. If you want to reduce the caseloads in your Georgia family courts so that your Georgia judges can spend more time on the difficult cases that need a lot of time, then adopt shared parenting, because you couple it with a parenting plan. About half of the parents, in my experience, in my research, will be able to work that out, and they don't need the court's time, and they don't need to be in the court system taking valuable time and resources that can be better spent on the cases that are complicated, where a judge needs to resolve disputed issues. You have a child.
I'm going to ask you to finish up, because
okay.
We've got some questions. I've got a question.
Okay.
That might articulate.
Okay. About 75 or 80% of divorces are started by women. That's backed up by a custody statistic that about 17 million non-custodial dads in this country today, about 4 million non-custodial moms. There's no good national divorce statistics because in its wisdom our federal government has quit keeping nationwide divorce statistics. But I can tell you that the big benefit, in my view, in terms of judicial economy toward a shared parenting presumption is, as a presumption, you always have the flexibility in the system to deal with those difficult cases where the presumption can be overcome. Those cases generally are self-evident. The cases that don't need to be in the system can be taken out of the system by the shared parenting presumption, and that will benefit the children who are the ones that are the voiceless ones that don't have anything to say about what happens. And I won't get into the constitutional argument. I may furnish a copy of the brief on the Illinois case, but I just want to tell you that as a student of the process, I can't think of anything more beneficial to both the load on the court's dockets and the fundamental fairness of encouraging people to work out their child problems without going to war than shared parenting legislation.
Thank you. Do you have, may I ask some questions? Mr. Lindsay.
I'm trying to figure out what the bottom line is. Today we're supposed to be focusing on those pages. When I go through your material, I'd like to get to the chase here. What you want is to have a mandated joint custody 50-50 presumption, correct?
Along the lines, yes, along the lines of the Oklahoma presumption for shared parenting.
And that shared for you means 50-50, correct?
Shared for me means treat the parents equal and basically tell them to go away, figure out a parenting plan, and if you can't figure it out, then the court will weigh in.
The presumption will be 50-50.
That's right.
I'm just trying to get the bottom line.
Right.
And what, in your opinion, would overcome that presumption? Is it the best interest of the child, or are you looking for a finding of unfitness?
I think constitutionally it would have to be a finding of unfitness, but there's a middle ground that you could reach because fitness is a high bar to overcome. I think best interest of the child is not a legal standard. It should be determined first and foremost by the fit parents. And the real problem here is that the custody model now treats all parents as though they're unfit and injects the court into micromanaging their lives even when they don't really need it.
Well, right now Georgia does have a best interest of the child standard, and what you're asking us to do is to set that aside and impose instead an unfitness of the parent standard.
No, I'm not suggesting you set aside the best interest. In fact, I think you ought to itemize what that means with a strong legislative preamble to that legislation to express the legislature's intent. The Texas Supreme Court articulated 9 elements in a case in Texas that I can furnish the committee that's some detail about what ought to be considered. I think the very best work available on what the best interest issues ought to be is in a work by Anna Freud and 2 others, a landmark work called The Best Interest of the Child, Before the Best Interest of the Child, and Beyond the Best Interest of the Child. And I'll furnish that book to the committee at my expense. I can tell you that family law universally around this country, they warn about numerous things that family law should not do to children. And in their book, which is mostly psychologically based but also deals with the legal and social aspects, virtually everything they warn against is common in family courts.
Anybody else? Ms. Manning.
When you discuss a parenting plan that these parents come up with, what's the difference between that parenting plan and a custodial, non-custodial relationship?
A parenting plan is worked out by the parents.
Yes.
And what's vitally important about that is parents have enough tension in the divorce process already over their failing spousal relationship. If the state of Georgia says as a legislative mandate, we want parents to work out their parent-child issues without dictate by the court, if at all possible, that sends a strong message that I think Georgia citizens will respond to for the most part. And when you have parents sit down and work out for themselves, not from the sense that if you can't work it out, one of you is going to be a huge loser, But with the presumption of shared parenting, they each have an incentive to treat the other with respect. They each have an incentive to treat the other.
Incentive?
Pardon me?
What gives them that incentive?
The 50-50 time that's the legal presumption.
The 50-50.
Right. In other words, if you and I are breaking up and we cannot work out our parent-child difficulties, if we know one of us is going to lose big time as the non-custodial parent, but the presumption says treat each other as equals, treat each other with equal respect and flexibility and accommodation like you did before this divorce started, and work out your own plan, I think most people are going to respond to that. It's cost effective for them. It takes the attorneys and the expense out of the war that is the alternative. And there's an enormous psychological dimension that's hard for me to communicate effectively in the time I have here. I was a mediator. I did court-appointed mediations, not in family court, but fairly big-ticket commercial mediation. Bargaining between equals is a fascinating process to watch. And what custodial, non-custodial as the default mechanism does is it tells both parents, you got to win this battle. If the presumption says you're going to be equal, work out your own plan, that completely changes the mindset of the parent that goes into the process. Instead of thinking this is a winner-take-all deal and I can leverage off the kids or use the kids as a weapon or whatever. If the presumption says you're both equal in law, which is consistent with the Constitution, and you both are going to get equal time, from the very notion that they're each going to get 50-50 time, they'll work out something radically different. 50-50 time in day-to-day life doesn't work for hardly anybody. But the presumption in law will encourage them because it puts them in a position to bargain as equals.
I think we understand the point.
Okay.
We're going to have to move on. I think the only question I would have is you mentioned the Oklahoma law. It's been in place for 10 years.
Yes.
I wanted to know, you said in your testimony that that would reduce court's caseload effectively. You have any experience with that in Oklahoma?
I don't, because I don't have any cases in Oklahoma, but I'll find out and send you a letter, send you a follow-up letter with whatever I determine, and probably my best service to the committee would be able to get you a contact person there who can speak authoritatively about what's actually happened.
I appreciate that.
Thank you.
Thank you so much
for the opportunity to testify.
You traveling all these miles to be here with us. Okay, let's move ahead. We got to move on to Mr. David Drake. Mr. Drake, you're from Marietta, Georgia.
Marietta, Georgia.
All right. There you go. Okay, Judy constituent.
That was quite a tough act to follow. Can I just say what he said?
Yeah, okay, next. We're looking for short.
It's kind of amazing. I am from Marietta. I'm a 47-year-old father of a beautiful, bright, dear 7-year-old daughter, and no, there's no parental bias in that description. But the points and concerns that I bring to the committee today are very similar to what was articulated by Mr. Thorne. I've got 4 general categories of concerns, and I'll be as brief as I can. Our current judicial policy in custody cases throughout Georgia inherently generates friction between divorcing parents. Parents that should truly be focused on doing what is best for the children and working together more often than not end up in embittered battles propagated by our current legislation and judicial policies and practices. Who benefits with this situation? It's been my experience that the attorneys on both sides always benefit financially from animosity created between their clients, not to mention the countless agencies whose job depends on maintaining friction and animosity between these parents, and some of them deal with domestic violence, which I'll speak to in a minute. Under our current laws and guidelines, everybody wins except the families that are involved, and this includes the children. This is unjust, unfair, and not in the best interests of families in Georgia. Concern number 2, custody decisions in Georgia are generally a winner-take-all arrangement. Let me back up by saying I have personally experienced all my concerns are first-person, personal experience. Custody decisions in Georgia are generally a winner-take-all arrangement. Everyone here knows that custody decisions are most often awarded based on little more than a perpetual bias in favor of mothers and against fathers. Fathers and mothers are not treated equally in our courts. It is a father who ends up losing in an overwhelming number of cases. Fathers in Georgia are generally and more often treated as second-class citizens in our family courts. This is unjust and unfair and not in the best interests of Georgia families. My concern number 3, women can abandon their families and file for divorce for any reason, as could men. But the onus is predominantly on the man to make all the sacrifices, provide all the finances, and make all the changes in his life in order to stay involved with his children. Our current policy makes it an uphill battle for fathers to remain involved with their children and in their children's lives, which is what our children absolutely and positively need and deserve, as can be proven by case after case after case of studies. Georgia's current policies penalize and actually punish fathers who want to remain involved in their children's lives. This also is unjust and unfair, not in the best interest of Georgia's families. And now, many of the opponents to a shared custody arrangement deal with the issue of domestic violence and abuse. And this, while a very serious concern, has implications. If a woman simply claims she is abused, a man is automatically assumed guilty, and all measures are levied against the man to remove him from his home, away from his children, and his life as he knew it. This is a common tactic and strategy used by attorneys representing the mothers in custody cases. There is no presumed innocence until proven guilty. If she says it, it is assumed to be fact, with no supporting evidence required whatsoever. No one in their right mind would try to minimize the seriousness of true domestic violence, but the judicial acceptance of the all too frequent false claims of domestic violence should not continue. Using domestic violence as a custody strategy not only minimizes those women who truly need the attention and care, but also strips the falsely accused fathers of their constitutional rights and their chances of remaining actively involved in their children's lives. This also is unjust, unfair, and not in the best interests of Georgia families. And I know we want to minimize our anecdotal presentation, but it remains a small piece specifically to the area of domestic violence. When I was going through divorce nearly 4 years ago, my wife and I were negotiating towards a shared 50-50 custody arrangement. Whether it was the attorney, her girlfriends, I don't know. She was made aware of the financial gain of getting sole primary physical custody of our daughter. And at that point, the tact and communications dramatically changed. She became aware of the numerous people that I had lined up to come to court, provide sworn statements and affidavits. I was the primary caregiver to our daughter. I am self-employed and could reasonably do so. The situation was that she didn't like the way that things were headed, so in a desperate act, she staged an incident of domestic violence, complete with calling the police out to our home. 2 police officers came to my house in the middle of the night, woke me out of a deep sleep, and informed me that my wife had filed a claim of domestic violence against me. To make a very long story short, both officers were trained in domestic violence and had investigated and had questioned her, were quickly ascertained that the charges were false and that no domestic violence had occurred and no charges were filed. The police officer came to court that day to testify on my behalf. The judge hearing the case would not let the police officer testify. He did provide me with a sworn affidavit, and I'll read just a quick blurb from it. It's Officer Jeffrey Reed from the Marietta City Police Department. He said, in general, I found Mrs. Drake's behavior and her responses very atypical of what you would normally expect to find under circumstances of a domestic dispute. In fact, very little about the incident fits the typical profile of a domestic dispute case. Additionally, there were certain facts that led me to believe that the whole incident had been set up by Mrs. Drake, that being, first of all, she was wearing a tape recorder and supposed to have taped the entire incident. Secondly, the parties had no previous history of domestic abuse. And thirdly, the father, who was a lawyer, showed up before we had left. Taking everything into consideration, we found no basis to make any arrests, and the case was closed. We did not believe the domestic issue was real. I advised both parties to contact their attorneys. I have seen firsthand many domestic dispute cases, and it is my personal opinion that the incident on this evening was staged and Mr. Drake was being set up. I was of this opinion even before learning that Mrs. Drake had a tape recorder turned on and was supposed to have taped the entire incident in question, which was not provided to us that night or the alleged that night of the alleged incident, nor provided in court.
You're running pretty short here.
I know. I'm going to have. In conclusion, basically, men and women are treated differently in our courts. The current system of dealing with divorcing parents involving children is sorely broken. Men are left with a sickening feeling of hopelessness, and I think we can do much better. It is not fair. There are a lot of good men, good fathers out there who want to remain active and involved with their children's lives, and I think we need to be given the opportunity to do that. Thank you.
Do you have any questions, Mr. Drake? Mr. Drake, we appreciate you coming down today, and thank you for your comments.
Thank you.
Okay. We have had, in prior testimony, and a lot of you have not been here for prior testimony, obviously, but in prior testimony, we've had similar anecdotes to Mr. Drake's, and therefore I think the committee has probably taken them pretty much into consideration in our deliberations thus far. And obviously, if there's a false situation that affects the custody issue, there probably ought to be something that we ought to be thinking about. The next person to give testimony would be Mr. Mark Howard.
Good morning, members of the committee. My name is Mark Howard. I'm a lawyer practicing in Atlanta and a resident of Sandy Springs. I've been practicing in law in Atlanta for about 14 years, and I hope you all won't hold it against me, but my first job in the law was working for Mr. Lindsay there.
Well, thank you so much for your testimony.
I know that takes most of my credibility away right now, but the reason I'm speaking today is not because of any particular expertise in my practice of law. I'm a plaintiff's lawyer, and in fact, the last time I testified, it was against the tort reform bill, so I'm batting zero here. I'm hoping you'll help me out a little bit. But in my practice of law, I have acted as a guardian ad litem through the Atlanta Volunteer Lawyers Foundation, of which Mr. Lindsay is a board member. I know he's done some of the same work. I also was a child in a shared 50-50 joint custody relationship from the age of 11 through the age of 18. I have been married now very happily for 11 years and have 2 small children. I don't have an axe to grind in this, but I do hope I can share with the committee some of my personal experience, which in one part may be anecdotal, but after having spent 7 years in a 50-50 joint custody relationship, I think it goes beyond just a mere example. Also, I think that my custody situation has been informed by the years I have spent, almost 9 years now as a guardian ad litem, working pro bono. So again, I don't have any financial incentive one way or the other. With all due respect to the prior speakers, my short statement to the committee would be, don't do 50-50 joint custody. It is the most colossally horrible idea you could possibly do for children. The standard in Georgia now under the law is what is in the best interests of the children. What I've been hearing in testimony today is what is in the best interests of the parents. Now, I understand that parents love their children and have their best interests at heart, but it is impossible for the parents to take away their own personal feelings of animosity and put those aside. I have seen that time and again, not only in my parent situation, but in my experience as a guardian ad litem. A guardian ad litem is hired or is appointed by the court to represent the best interest of the children. They don't do what the children tell them to do, in the classic sense of a client telling a lawyer what to do. But the court charges an attorney to look out for the best interests of the children. And I have seen situations of joint 50-50 physical custody between parents, which again have placed the child in the middle. Now, from my own experience, I can tell you that my parents were well-meaning. They're good people. I have a good relationship with them today. I love them very much. They were highly educated, had sufficient income, and I lived in a small town where a drive across town was 5 minutes. They were divorced when I was in middle school. There was one middle school in town. There was one high school. So there was no question of school districts. There was no question of driving from Conyers all the way to Douglasville. Those issues that you might find in a big metropolitan area didn't exist. And my parents came up with their own plan, a 50-50 plan. They went out of the court system and they drew it up. Monday, Wednesday, Friday, Saturday with Mom, Tuesday, Thursday, Sunday with Dad. It was a horrible arrangement. It was an arrangement in which I personally had to pack my clothes every day and take one bus to school, shove everything I owned into a locker, take it out at night, drive a second bus back. It was a situation where on holidays, because they had worked out this enlightened plan of 50-50 joint custody, I would have 2 Thanksgiving dinners. I would have Christmas morning with Dad, Christmas evening with Mom. It was a horrible arrangement. If my brother were here, he would tell you the same thing. It is a situation in which the child is forced to become the arbiter of disputes because they don't want to get lawyers involved. They don't want to get the court involved. They don't want to get a guardian ad litem involved. Instead, the child becomes the messenger between parents. If you have a joint 50-50 relationship where no parent is responsible for making the ultimate decision about what's in the best interests of that child, I can guarantee you that the child is going to be the one making those decisions. And a child should not be placed in that position. Someone has to be the adult, and someone has to have the ultimate authority. And in this state, right now, we have the best system for doing that, which is the best interests of the child, which can be determined by a court which has heard the evidence, and by a guardian ad litem which makes recommendations to the court. I've heard this morning testimony that there is a bias against fathers. I don't believe it, and I don't believe it. And cat calls aside. I've been in the courthouse. I've been the one making the recommendation.
Let me stop you for a second. We conduct this in a gentlemanly fashion in this room, and if you can't act in that way, we're going to ask you to leave. We'd like to not have that type of performance again. You may continue.
Thanks, sir. I can say, in all honesty, in 9 years of being a guardian ad litem, about 50% of the cases that I have made a recommendation to the judge, and I have recommended that custody be given to the father as opposed to the mother. And I can also say in 9 years of being a guardian ad litem that not once has a judge rejected my recommendation. I have been subjected to cross-examination as a guardian ad litem, and I have then gone to the other side of the podium and cross-examined the parties themselves. I have gone to in-home visits, and I have traveled out of state to schools where children have been sent. I have spent an enormous amount of time with children. And the judges of this state put a lot of credence into the guardian ad litem program. If anything that this committee could recommend, it would be to strengthen the guardian ad litem program so that neutral attorneys or other people appointed by the court to come in and look at these situations can make recommendations to judges so that sound decisions can be made. But in my situation, as I can tell you from growing up, it was very easy for me, in fact, to get away with a lot, especially entering my teenage years. If I was half the time with Dad and half the time with Mom, and neither of them really had to take responsibility for what they were doing, it was very easy for me to get away with things. And it was very easy for me to tell one parent that I had already received a report card and had given it to the other parent. No one had the authority or the responsibility to make a decision. And as a result, that devolved on me. And I would say that my life would have been very different if I had not had a very strong coach who saw the situation that I was facing and came in and started helping me make decisions for myself that otherwise my parents should have been making. Again, they're not bad people. They're lovely people. I respect them greatly, and I know that they had my best interests at heart. But they can't make that decision. They can't make, if both of them have a 50-50 authority and have equal bargaining power, chances are no one's going to make the decision other than the children. And children, frankly, can be very manipulative in those situations, too. Finally, I have been told, I wasn't here at the prior committee hearing, that a young man came in and testified. I may be incorrect about this, about his joint physical custody situation, and testified it's a good thing. I probably would have said the same thing myself at 15 years old. I loved my parents. I believed that they were doing what was in my best interests. How could I argue with seeing both my parents every other day? I turned 40 in 2 weeks. Again, I'm sorry to say, but looking back on it, I would not have trusted the judgment I would have exercised at 15 years old to make a decision about that. Listening to a 15-year-old boy talk about what's in his best interests in terms of custody is a huge mistake. And if there is simply one thing I can just tell the committee, it is that you would be affecting thousands of lives in the most negative way imaginable if you made joint 50-50 custody the standard in this state. It is wrong-headed. It would be a disaster. And I'm happy to answer questions.
Thank you. Questions of the committee for Mr. Howard? Well, why don't we start down here with Mr. Butler.
I don't know if I exactly have a question or more of a statement, just because of the fact that I've listened to you patiently and I've listened to other people. And I'm going to have to say, I haven't really agreed 100% with anybody up here. And I don't agree with you 100%. Because really, I think a more correct statement of what you said, you said that you think that shared parenting is probably is a really bad thing. It would be my opinion is, no matter which road you're on, whether you keep the system we've got or go to this other system, they're both bad for the child. There's no other way of looking at it. And, the best interest of the child is for mom and dad to get along and work all that out.
I'll certainly agree with that.
Of course, that's also speaking of a perfect world where we've got two parents that will act like parents. And I understand that. Being a parent who's in a joint legal and physical shared parenting situation myself. So when I hear you talk about your situation, I understand it from the other side as being the parent who decided to do what your parents did. And I agree with you that the system that you told us about was not a good system, the every other day type situation. But I think the gist of what we're trying to get to, and I think a lot of people are taking this thing out of context and they're getting off and going off on tangents. And I want to try to just speak just a minute, try to get everybody back on the same page. I don't think it's so much of some of the stuff that's on the fringes that we're talking about that I think that most people have a problem with. I think it comes down to that the legal custody is where the real sticking point is at. Coming from somebody who's gone through it, the one thing that probably turned my stomach the most was that somebody else, somebody like you or a judge, was going to tell me that I no longer had a voice in the decisions affecting my child. That right there is what we're faced with today to look at. Is the system truly fair when you've taken and raised a child for 10 years and you've been an integral part of that child's life and decision making, and then somebody else tells you that you can no longer be a deciding factor in the things that affect that child's life? You may can voice an opinion, but your opinion can automatically be overrode just because somebody else said that it could. I think that's the sticking point that we're trying to get to. The physical custody part, all that, that's all, needs to be worked out. I understand the difference in that, and I understand the fact that a child needs to have kind of a home base. I do. I get that. But I think what we are losing sight of in here is the fact that the best interest of the child, at least in my opinion, is that both parents need to be involved in the raising of that child. Even if they can't get along with each other, that child needs and has to have both parents giving them guidance.
Mr. Butler, I appreciate your comments. I think we're not here to represent an opinion for the committee at this point in time. And so Mr. Butler is speaking from experience, and hopefully it's taken that way. There are some other questions. Go ahead, Judy.
What would you think about the age of election being 14 as a guardian ad litem?
Frankly, I have serious problems with it. 14-year-olds most children are manipulative at some level. My 3-year-old does a pretty good job on me. But 14-year-olds in particular who are then invested with that amount of power to make that decision without any adult supervision over that decision concerns me. And I plead ignorance in terms of any statistics or studies about that. I certainly think a child of that age should be listened to. And as a guardian ad litem, I certainly would listen to any child, but the closer they got to that age of 14, the more weight I was going to be giving to their particular opinion. However, I also saw children at age 14 tell me flat up, hey, as soon as I'm 14, I'm going to start using this as a bargaining chip with my parents. I don't think a 14-year-old should have the burden of making that decision. I also don't think a 14-year-old should have the power to make that decision. Certainly their voice should be heard, but let's face it, when you're 14 years old, you can't drive, you can't vote, you can't drink. Why should you be given the sole discretion over a judge, over your parents, over a guardian ad litem, over teachers and other people who are involved with it? I think certainly they should be listened to. But I can think of a case in particular where I went and interviewed the teachers at a teenager's school, and that young man who was about 13 was just chomping at the bit for his 14th birthday so he could start bargaining with his parents, and the teachers were well aware of it and shared that with me.
I think we've heard testimony in previous situations that parallels that. Mr. Lindsay, you have any questions? I have one question.
Yes, sir.
And that, doggone it. Every time I look at Mr. Lindsay, I forget what my question is. To tell you the truth. I wanted to know from you, there have been states that have added specificity to the best interest code. And, in fact, they put factors into the best interest code that the judge has to review. And then they've also stated that the judge must put his decision in writing with relationship to why he's making a decision based upon those factors. Do you think that's a good idea?
Without having given it as much thought as I would like, I would say that certainly the legislature has an interest in stating that what factors a court can consider, and the importance of that is then it gives some sort of template for a higher court then to review a lower court's decision and determine whether the judge has applied the law. I do think that, unfortunately, there's an atmosphere around the country that judges somehow are people who are wildly out of bounds with the norms of society, that we have activist judges. I will tell you that judges generally, especially in situations like this, try their very best to do the right job. In fact, with the exception of maybe death penalty decisions, what I have seen is that domestic cases tend to be the ones that produce the most anxiety for judges because they realize the consequences. Giving judges a set of guidelines, I think, is not a bad idea, but I don't think it should be done to the level where it would remove all flexibility and discretion from the judge, because those are the people who are there listening to the testimony, listening to the guardian ad litem. So I'm not sure if that answers your question directly.
It does, and particularly on the issue of appeal. I think it does set a standard for appeal. We appreciate you coming in today, Mr. Howard. Thank you so much.
Thank you very much. Appreciate your time.
We're going to move to Mr. Taylor next, and then we're going to break after Mr. Taylor comes, so you can look forward to that. So, Mr. Taylor, you're the only thing standing between these good people and a brick.
I'll be brief. Thank you, Mr. Chairman, members of the committee. I will be as brief as I possibly can, and going to Representative Butler's comment, I'll try to be concise. As I understand my testimony before the committee today, it is one to advocate for shared parenting and joint custody in divorce situations. By way of brief background, I hold a PhD in psychology from Counseling and Psychological Services Department at Georgia State University. In addition, I hold a law degree and currently practice in the area of family law, representing litigants in all aspects of domestic cases. Fully 90% of my practice is family law. As many lawyers will tell you, I've won cases I should have lost. I've lost cases I should have won. And in the mix of my practice comes a guardian ad litem focus as well. The realities in my experience and practice, after having spent time in the public school systems as a psychologist, having served as a consulting psychologist, and now having practiced for many years in the area of family law in Georgia, specifically in Marietta, with a practice that takes me into Cherokee, Paulding, Cobb, Fulton, and even into the northwest reaches of the state, it is my understanding and my experience that leads me to a decision and what I would encourage and employ the committee to decide, and that is on and in favor of a shared parenting scenario. My reasons are really threefold, but what I want to express first and foremost is that the issue of how to provide appropriate and adequate parenting in the context of divorce is an issue that, frankly, is of great concern to family lawyers, it's of great concern to mental health practitioners, and it's of great concern to the public in general. I think this committee stands in a unique position to facilitate not only the best interest of the children of the state, but also to facilitate some transition as it relates to family law in Georgia through the guardian ad litem programs and through the ancillary opportunities that could be espoused should a shared parenting scenario be passed, proposed and passed. Children take many routes through divorce. I've seen it firsthand. I've seen it as a guardian. I've seen it as a litigant and a lawyer. They encounter their response to this process depends largely, in fact, on the risks and protections that they face early in the process. By risk and protections, what I'm talking about is what their parents have to offer them, and frequently the onus needs to be placed back on the parents rather than on the judiciary itself. It's difficult to predict how any divorce will affect a specific child, as all children are unique and have opportunities. They develop differently. They are simply different. But the one thing that is for certain, when you can provide, and parents, and I suggest this committee, can provide as many protections for children as possible early on in the divorce process, it's better for the children, regardless of their age, regardless of their developmental stage. And I suggest this committee can do exactly that. That is, provide a protection for children through a shared parenting process. How? Ladies and gentlemen of the committee, I suggest that there are three ways that you can do this. One is by increasing communication, and I'll go into that in a little bit. The second is by increasing control and self-determination of the litigants. And sometimes what is perceived as an often hostile and inhumane world that's known as domestic law in Georgia. Fully 90% of my practice focuses on hotly contested custody cases. I will state for the committee that over the course of September, the bulk of my month was spent in jury trials, contesting custody, calling experts, and trying to advocate for my clients. Secondly, I believe that through a shared custody or shared parenting scenario, you increase self-determination by providing the litigants a roadmap, if you will, if judges then are forced to delineate specifically what reason that presumption has been overcome in a temporary hearing. What are the reasons behind placing primary physical custody with one parent over the other. And that gives the non-custodial parent an opportunity to mend his ways or her ways, as the case may be. Finally, I think that a shared parenting scenario creates an opportunity to cooperate in sometimes a hostile world because of the presumption and because it would exist out of the gate, so to speak. It's not uncommon, and I've heard in previous discussions before this very committee, the fact that judges often and have, and I will state in my place again that I've actually heard it, that calves don't follow bulls. Well, the reality is that that's not the same society that we live in today. And it's hard as a litigant and it's hard as a psychologist to explain to your client, I don't know why that judge said that particular thing. I have no, we tried our best. To go into the specifics of why I think a shared parenting and joint custody arrangement is appropriate for the children of the state, I'll begin with my first point. That is, I believe it causes an increase in communication. How? Well, the presumption absolutely would increase communication between a mother and father by necessity. It thereby restores some of the dignity and respect that these litigants began their relationship with. I don't think there's any dispute that two people get married with a certain amount of dignity and a certain amount of respect that is oftentimes lost through the domestic process. Increasing communication through a presumption of shared parenting restores some of that dignity and respect that they came into the marriage with, regardless of hurt, regardless of anger. And I'm not speaking here of the extremes. I'm not speaking here of the abuse scenarios or anything of that sort. I'm speaking of the typical divorce case that presents itself to the superior courts of this state. Under the current dynamic, there is a power focus. And following a temporary hearing under our current system, there is always a shift in the power dynamic. And that shift is always in favor of the person delineated, the primary custodial parent. In reality, that can typically come after a judge has made a temporary ruling or after a guardian has issued a presumptive report. Once that scenario occurs, it literally creates no impetus, or it removes any impetus to communicate between the parents for the children. You have one parent, the custodial parent, who has now been placed in a superior position versus an inferior parent. For what reason? Well, under the laws of Georgia, it's typically your client and one witness who get to testify. Everyone else has to testify via affidavit. So it's not even a live human being. A judge is then basing his or her decision on two people, for you and two people for the opposing side. And there aren't a whole bunch of opportunities other than those affidavits to get any further evidence into court. In fact, it will typically be excluded. The second way that a shared parenting scenario will, I believe, benefit the best interest of the children of Georgia concerns the increase in control it provides to litigants and one of self-determination. What do I mean by this? It follows that if under a temporary hearing, even under a shared parenting scenario, the judge finds that one parent is the best custodial parent and awards custody to that person, that the judge should then delineate, much the same as we have in juvenile court cases now, exactly why that parent is the better suited or situated parent to maintain control and have final decision making over the children. This is not an unknown or foreign concept. In fact, if the committee will refer to the juvenile code, this is exactly what we do in deprivation cases and termination cases. And I'm going to laugh for a moment and digress, because truly a man that I feel was extremely important in my legal upbringing is actually sitting right back there. And he's the one who taught me that. That's Judge Jim Morris. Judge Morris is the one that taught me that many, many years ago, and he probably doesn't even remember it. But the reality is that we do that now in juvenile court cases, where there's a delineation of exactly how this parent has failed this child and what steps then can be taken to remedy that failure. Currently, we have a judge who says, based on the testimony, typically of 4 people, that one parent is better than another parent in terms of raising the children. But there is no delineation of fact. There is no finding of fact. There is no discussion as to why that is indeed the case. And that goes to a rehabilitation issue, which is, can that person rehabilitate and then stand in the same shoes? I suggest that a shared parenting scenario, which requires or suggests to judges that they need to have findings of fact as to why one parent is better than another, allows a certain amount of self-determination. And the non-custodial parent could then make a choice of whether to improve his or her position prior to a final hearing. Finally, by necessity and just out of general fact, it increases cooperation between the parents. A shared parenting presumption increases cooperation out of necessity because it no longer shifts the power dynamic between the litigants. I think this is just a necessary consequence of this type of scenario. I do want to, and I wasn't going to address this until recently, but I do want to address one thing. I've had the pleasure and the pain of serving as a guardian ad litem in the state of Georgia for a number of years. I find our current system woefully remiss in the way guardians handle cases. I find that's both as a lawyer and as a psychologist. I've been put in numerous scenarios where guardians are not trained in the developmental, social, emotional, mental health, or personality characteristics of our children, much less the litigants. They are unaware at times of the stress that divorce actually causes. Now, I don't want to badmouth all guardians because I have truly experienced guardians that were remarkable. But our guardian system today, as it stands, is woefully remiss to the children of Georgia. And I believe that through a shared parenting scenario and through a joint custodial scenario as a presumption, we are put in a place to benefit the children and help them by installing a protection early in the divorce case that can't be accomplished by a guardian who has simply had no training or had an 8-hour workshop through AVLF. On how to deal with parental alienation syndrome, on how to deal with depression and divorce, on how to deal with the big stressors that face litigants in a divorce, and that truly litigants often act in ways that they wouldn't normally act. I know I'm running out of time. I promise to be brief. I appreciate your listening, Mr. Chairman.
Well, look, Mr. Taylor, thank you for your comments. We've had a lot of testimony on the Guardian ad litem program
Right.
and other venues. Are there questions for Mr. Taylor? Mr. Lindsay.
Yeah, based on your experience, I did have, I believe it was Mr. Thorne earlier acknowledged that in reality, 50-50 time split doesn't work in most families. Would you, based on your experience, also agree with that?
You know, I think it's going to be highly dependent. This is a great lawyer answer.
Please answer.
I believe.
You understand?
I believe it depends.
You understand? If you're a lawyer, you understand the concept of answer the question and then you may explain.
I don't think that a cut and dry 50-50 is always in the best interest of the child. No, I do think you can, based on current calendars and school calendars, come to a fairly equal scenario. I do not agree with the day on, day off. Yeah. I think that you can weigh those things depending on the circumstances so that they approach 50-50 over the full calendar year, not necessarily every day. Does that make sense? I'm not sure if I answered your question.
In the cases that you handle, most of the cases end up with one parent or the other having more time, physical time, than the other, correct?
Correct.
And that's usually in the best interest of those particular children that you deal with.
That is typically, in the case of a 14-year-old, as you well know, that's based on fitness as a parent rather than best interest, but that is correct.
Anybody else? Mr. Taylor, thank you for coming in. We really appreciate it.
Thank you, Mr. Chairman.
We're gonna stop right now. We're going to take a break. You've eaten in your break time successfully. And so we're going to reconvene here at 11:30. 5 minutes. I'd like to have Mr. Rick Leeds come up. Well, there you are.
Right here.
Okay. All right. How about, would you turn the button on? It's not red.
It's red.
It's red. Okay, good.
I'm going to try to set the bar for speed for you. So
Well, I appreciate that.
get through as
Thank
many
you.
people
And
as
seriously,
possible.
I know some other people would like to testify in here today, and after sitting up here for for 3 sessions now, I can tell you that we are hearing some of the same things, and that may reinforce a particular point, but it doesn't necessarily establish new ground. And so we would like to try and move to the areas that are most efficient for us. Let's put it that way. Thank you.
3 minutes, 50 seconds. That's
was
okay.
that what I had?
No, that's what I had. But that's okay. Well, I want to thank you for the opportunity to speak. My name is Rick Leeds. I'm from Marietta. Seems to be a large population of us here today. And I'm a father of 2 girls, ages 11 and 13. I'm a non-custodial parent. I have my children 15 days short of half the year by a bench trial. And so it's kind of a unique situation. Their mother and I live about 2.5 miles apart. Had the whole court-appointed psychologist and guardian ad litem. To save time about the whole specific issue, I included an article in what I just passed out to you. It was an op-ed article I wrote for the AJC, and surprised to find out they didn't want to print it. But I want to share it with you. I've listened to the last 2 meetings on tape, and I want to add a new element that maybe hasn't been discussed here to kind of show some of the inequities in the current law, especially along the line of definitions. And that has to do with the Georgia Public School codes. Each county, as you're aware, has their own codes. And I've downloaded numerous ones from the website. Most of them are from your county, so you can take a look at them, and they are in alphabetical order. So let me just point out some quick highlights, and then I'll be done. Due to the weak language in definitions of parents in the current Georgia Code, school districts take it upon themselves to kind of create their own definitions and rules. Not one Georgia school district properly defines legal custody or physical custody. Most counties don't even address divorced parents. Atlanta Public Schools is one, and Gwinnett County is another. This leads school principals to just kind of make up the rules as they go. Some go to extreme assumptions. See the underlined section of the Carroll County School Code. Mr. Butler, that's your county. There's Carroll County. It says, when a student's parents are divorced, the custodial parent has the right to determine the child's upbringing, including his or her education. Now, this is not true under current Georgia law. It's not what the definitions of the law say being a custodial parent is. And it's reiterated in Coweta County and also in Cobb County. A custodial parent may have the final decision-making power, but they may not. But it's not generally exclusive. And as a non-custodial parent, I'm supposed to be involved in the decision-making. So for the school district to say the custodial parent just has exclusive all decision-making power is really not even in line with what Georgia law says. But it appears that the counties ignore this fact. Some counties, such as Chatham County, Savannah-Chatham, don't feel obligated to have a conference with the non-custodial parent. Yet at the same time, they afford that parent the right to review all records. They just don't have any discussion about the parent participating or having a conference. Cherokee County says the custodial parent is the parent whose parental rights have not been terminated. I'm a non-custodial parent, but my parental rights haven't been terminated. It goes on to say that it is also who has been awarded sole or primary custody of the child by a court. Well, again, I'm a non-custodial parent, but my parental rights weren't terminated. They go on to say very admirably that both parents are encouraged to participate in all activities in the school. Now let's drive a few miles south to Cobb County, and of course that's where I live. Cobb County has a special section just for non-custodial parents. It's the only code that I found on the web that actually is special. It says it gives me the rights to my children's records and school pictures, but it says I have to provide a notarized request to the principal 45 days in advance of wanting it. Now, that's, again, not part of Georgia Code, but Cobb County then is setting its own rule. A school semester only lasts 90 days, and I have 45 of them, of course, that I have to wait before they'll give me an answer. I have to do it 45 days in advance. It says I can attend public functions, but I can't go to lunch with my child. And when my children were in elementary school, that's a big thing. Now they're middle schoolers, and it's like, stay away from school, Dad. We don't want you anywhere near it. But, of course, elementary school was a big thing. Now, in Cobb County, it says I'm not allowed to as a non-custodial parent. Well, I can get their mother's permission to, and then maybe they'll let me to if I do it 45 days in advance and I notarize it. So this is what we're dealing with. We're dealing with laws that start out and they're weak to begin with, and then we have a whole other group or individuals that are making laws like school districts, and they take it upon themselves to just make up all their own as they go along, and they kind of ruin the definitions we have. So I really want to express to you that these definitions are really important. I'm a non-custodial parent. As you read the op-ed article I wrote, it's kind of a badge I wear, and I'm kind of honored in a way to wear it. it doesn't take away my responsibilities as a father, and you know, I take that very seriously. But when other things like school districts, when I have to overcome these things, it becomes almost impossible and difficult. Now, here's the rub. Everything's good in Cobb County, where my kids go to school in East Cobb, because the teachers make it happen, and the teachers invite me to do things. But in essence, these teachers are breaking the law. I don't want to put them, they're breaking the rules of the school district, and I don't want to put them in any harm's way by inviting me to read a book to my child's class or go to lunch with my child. So we really have to strengthen these definitions. Non-custodial parent doesn't mean no parental rights. It just means I don't have final decision-making power. It does put me in a position where I need to be involved in making the decision, though. And I think that we lose that when our law doesn't come very clean and express that. When school districts can say that the custodial parent is the only parent who can make a decision, that's wrong. It's wrong under current Georgia law. So I guess my point is, when I got divorced, I gave up the title of husband, but I didn't give up the title of father. And I shouldn't be treated like I'm some kind of other class of parent who requires a notarized request to the school every time I want to get records. It's not only limited to schools. The same things, this is just what I wanted to diagram for you, but it happens in medical practice as well. Going and getting medical records when you're a non-custodial parent, even if you're the insured, can sometimes take a tremendous amount of energy. They want someone else's approval for me to know what's wrong with my daughter. And I'm challenged by that, especially because the law could make that very clear. Legal custody in Georgia, to most people, means that I don't have to adopt my children if, God forbid, their mother died, that I wouldn't have to adopt them. That's the only thing that legal custody gives me as a non-custodial parent here in Georgia. And again, that's not what we expect it to be, but it's really what people perceive it to be. So one last thing I want to leave you with real fast. We talk about shared parenting and joint custody. My daughters are preteen, 11 and 13. And, both in middle school, and they're getting to that age when things like puberty are setting in. Right now, I have 15 days short of half the year. I recognize that right now, my daughters are probably going to need their mom a little bit more than they need me as they go through some of the changes they're going to go through. And I have to, as a parent, understand that and be flexible with that and co-parent with their mom. If it means giving up some time with my children, well, okay, I'll do that. But not if it's going to hurt me. Not if under the current law, I'm going to be dragged back to court for failing to exercise my visitation. Might be a good reason to. I want to co-parent. Be perfectly honest with you, my children's mother and I don't get along that well. We do all our communication by email. And actually, I'm very happy with that because we can take a day and strip out all of the negative things before you send it. And then it's a business letter. And it's wonderful. We can actually, after 6 years, communicate facts back and forth to each other. And it's great. We do, I think, an exceptional job of co-parenting for two people who never hear each other's voice. But my kids understand, my daughters understand, that mom makes all the rules. So my concern is, what happens when my daughters become mothers themselves? Are they going to honor their spouse's decision? Because all they know is that mom makes all the rules. If we change that, if we change some of the presumptions, everyone shares in making the rules. And I think that's what's most important. I am finished. Any questions?
Thank you, Mr. Leeds. I think that is a different perspective that we haven't heard before, and that was good. Questions from the committee? Mr. Lindsay?
I think the school thing is a big issue for a lot of people.
And I commend you for it. My question to you, have you had an opportunity, your organization had an opportunity to look at some other states or perhaps consider legislation yourself in terms of the language on how to rectify this situation? Because, like I said, I commend you for trotting new ground here, because this is something that we haven't heard yet. But I understand the points that you're raising, and particularly when it comes to having equal access to the teachers and that sort of thing.
It's we haven't. For those of you who don't know, I'm with Georgians for Child Support Reform, which is now Georgians for Family Law Reform. But it's certainly something on our discussion boards that I'd be happy to do some work on and then bring up to you further.
I would commend that to you.
Absolutely. Thank you very much.
Thank you very much. We appreciate that. Okay. Let's move on to Chris Woodham. Mr. Woodham, if you could focus on those things that you think are
Yes, sir.
new and untoward ground, that would be great.
I'll do my best. My name's Chris Woodham, 36-year-old father of a 4.5-year-old child. I'm in Woodstock, Georgia. And I want to initially start off by saying I really don't have a personal stake in this issue any longer. I currently have a joint physical shared parenting arrangement with my daughter. However, I'm speaking because I personally do not believe any fit parent, and I think the term fit really needs to be defined because judges have too much discretion as to what fit means nowadays. I really don't want to see any fit parent that seeks equality with his or her children ever have to go through what my daughter and I had to go through. Unless you've been through a custody battle, you really can't fathom the outright injustices being done by or to men, women, and children alike. And I won't go into a lot of what we've heard already, but one of the gentlemen speaking previously stated that he didn't see the biased nature within the judges' court system any longer. And Mr. Taylor actually provided part of a quote that I'll provide you specifically from a Georgia judge named Robert Nolan here in Douglasville, who routinely placed children in mother's custody when he tried divorce cases. And he justified it when he said, and this is quote within a transcript, "I ain't never seen a calf follow a bull. They always follow the cow. So I always give custody to the mamas." Well, my point is, Judge Nolan never saw a calf follow a bull because cattle don't live in two-parent households. Now, I've sat here the last several weeks listening carefully to the opposition side to this piece of tentative legislation, as well as the many objections to this legislation. And I'd like to take a few moments, if I may, to address some of the more prevalent objections I heard that would oppose shared parenting. The first thing I heard was the issue of domestic violence, over and over again. And in my research in the last year, it was pretty conclusive to me that the domestic violence claim was used often after the fact. I knew many couples that were married 10, 20, 30 years, and domestic violence had never been brought up until after child custody had been raised or ensued. The opposition states that non-custodial parents, that giving non-custodial parents equality with their children will in fact perpetuate or increase the likelihood of domestic violence. I personally don't understand the correlation between that, and I'm hoping that maybe the opposition can clarify that. But maybe what they're saying is that a joint physical custody arrangement will increase the likelihood of having interaction between the parents, thus increasing the likelihood of an altercation leading to domestic violence. Well, if you've already got visitation with your children, and I hate the word visitation, I think it should be required, mandated, that it should be custodial parenting time, that increasing that visitation, how does that increase the amount of time with their child, increase the likelihood of domestic violence? I drop my child off on Monday mornings, mother picks her up Monday after school, and we don't have to communicate with each other, and it happens the next week. So therefore, increasing the amount of custodial parenting time didn't increase or doesn't increase domestic violence, in my opinion. Besides, the considerations that the committee came up with for shared parenting, I believe, address a lot of the domestic violence issues that I heard from the opposing side, such as a mandate that absent parental unfitness, a court will not award shared parenting. Personally, if one parent is proven to have committed domestic violence against another parent, I believe that would be deemed as parental unfitness, and there will be no shared parenting arrangement. I don't believe that there's going to be any piece of legislation that will ever cover every conceivable situation. Again, I believe that one of the opponents of shared parenting that spoke earlier, I believe his name was Mr. Wilson, who was a product of shared parenting. He seemed like a pretty good guy. He seemed like a guy that came out of a shared parenting situation, and he turned out to be a pretty outstanding citizen. Whereas if you look at the facts in sole custodial situations, on some of the information I'm sure you've heard many times, on page 3 of the handout I provided you, children that are father deprived are 72% of all teenage murderers, 60% of all the rapists, 70% of all the kids incarcerated, twice as likely to quit school, and so on and so on. Many of these facts you can find elsewhere, and you get these from objective sources such as the U.S. Bureau of Census. Now, in addition to my research, I found that the National Coalition of Domestic Violence states that over 50% of all women experience physical violence in an intimate relationship, and for 30% of those women, the battering will be ongoing and regular. When Rita Smith, the NCADV coordinator, was asked where she got these statistics, she stated, quote, "These figures are only estimates derived from what we hear from women's shelters and other advocacy groups." Well, my point is if these statistics are valid, and even though I'm not married, if I'm not beating my wife, then my next door neighbor's beating his, and the guy 3 doors down is beating his on a regular basis, and in my subdivision of 3,000 homes up in Cherokee County, then approximately half of those homes have domestic violence on a regular basis. And I just believe those statistics are quite skewed, so I went and looked for a little bit more objective resource, and I found that the NCVS, the National Crime Victimization Survey, which has been ongoing since 1973, collects data, and they're the largest national forum for victims describing the impact of crime and the characteristics of violent offenders. Twice a year, they obtain data from a sample of 49,000 households comprising of 100,000 individuals. And since 1994, the NCVS concluded that domestic violence committed by men on women has decreased, while domestic violence committed by women against men has risen. In 2004, the NCVS found that intimate partner violence, defined as violence committed by a current or former spouse, boyfriend, or girlfriend, occurred in 1 out of 250 households, which is 0.4%. It is noted that of the 116 million households in 2004, there were 458,000 households, or 0.4%, with 2.3 million households with simple assault, and 750,000 households where aggravated assault occurred. So of the 0.4% that received domestic violence reports, 15% of those were crimes committed by women against men, which results in an even lower incident of domestic violence committed by men against women. Now, I don't think anybody's here to trivialize domestic violence because we do know it occurs. I'm just trying to provide a little bit more realistic portrayal based on objective resources that I found. Another objection I heard was the opposition regarding control. Now, I may be just a simple country boy from the backwoods, but that objection to me reeks of hypocrisy. Essentially, this argument totally discounts the idea that fathers actually love their children, might actually want to be part of their lives. It also labels the father as a control freak, simply because he desires some say in how the children are raised, as if he had no right to do so to begin with. So I think most of us, as far as fathers and non-custodial parents, are only asking for equality for our children. It's what the children deserve. It's what the parents deserve. So it's the other side, the opposition, that's fighting vehemently to maintain control. So, again, I think there's a little bit of hypocrisy there.
Mr. Woodham, you're about out of time here.
Yes, sir. I understand. I just would like to sum it up, though. If you look on the front page of this piece of information I provided you, this was another statistic I found that shows that a direct correlation between joint custody or shared parenting awards and the divorce rate over a 19-state sample showed that as joint or shared custody arrangements were on the rise, divorce directly correlated to that and was on a decrease. And what this study proved was that over time, the divorce rate dropped dramatically. And I think that's what we're trying to do here, is for the best interest of our children. If we can lower divorces, if we can provide a shared parenting, again, I don't think it's a matter of 50-50 visitation. I think too many people are sticking to that and I think parents are trying to get 50-50 visitation, and I don't think that is really what's ultimately most important. I think the visitation or the custodial parenting time will work itself out. For me personally, there are 4 legal aspects in joint legal custody. It's the educational, it's the medical, it's the extracurricular, and it's the religion. When I was in a sole custody situation, I had absolutely no say-so. Even though it said joint legal custody, basically I had my say-so, and then she made the decision. She took her out of the private school I had, placed her into another one, and I had no say-so in any of these things. So I think it's the joint legal aspects that really need to be defined. And if you can find a way to provide equality on the joint legal aspects of it, the visitation or the custodial parenting time will work itself out.
Thank you so much. I appreciate you coming in today. Mr. Woodham, are there any questions for Mr. Woodham?
No.
Okay, thank you, Mr. Woodham. Shelley Centerfit.
Thank you, Mr. Chairman, members of the committee. My name is Shelley Centerfit, and I am here on behalf of the Georgia Coalition Against Domestic Violence, as well as my law firm, Centerfit & Knight. I am a family lawyer here in town. 100% of my practice is devoted to family law cases. I also serve as a guardian ad litem through the Atlanta Volunteer Lawyers Foundation. And my case involves representing parents and kids who have been impacted by domestic violence, as well as families in which there is no allegation of domestic violence. I am not going to repeat what my colleagues last time said regarding domestic violence, but trust that you all recall the range of testimony that was provided about the incidence of domestic violence and its impact on kids. So I'm going to try to focus just on some new things that we haven't talked about yet. I would encourage all of y'all to reread the Georgia current code on joint custody if you haven't done so already. I was actually surprised when I went back to it and saw how many references there already are to ensuring that joint custody is appropriately considered. For example, Section 19-9-3 says there is no prima facie right to the custody of the child in either the father or the mother. We're supposed to be starting off from a level playing field. Section 19, that same section also says joint custody may be considered by the court, and joint custody is defined as joint physical and joint legal custody. Furthermore, 19-9-3 subparagraph D provides that it is the express policy of this state to encourage that a minor child has continuing contact with parents and grandparents who have shown the ability to act in the best interest of the child, and to encourage parents to share in the rights and responsibilities of raising their children after such parents have separated or dissolved their marriage. And finally, 19-9-5 notes that the court shall not refuse to ratify the parents' agreement based solely on the choice of joint custody. In other words, if those parents decide we want to have joint custody, a court can't just say, no, I disagree with you from my personal perspective. The court's got to provide specific written findings that the agreement is not in the child's best interest. I share this with you to say that we already have some strong language on the books regarding our public policy in favor of promoting continued contact with both parents following divorce. Now, that being said, I'll also be the first to admit that sometimes the judges don't follow the law. And I certainly would agree that some additional training would be appropriate for our judges on what the law currently provides and what the current research is showing about what's best for kids after divorce. I would urge this committee to consider working with the Council of Superior Court Judges to see if we couldn't provide some specific training on how to handle these custody cases. Additionally, I would urge this committee to consider actually getting some hard data about the state of custody awards in Georgia. Many of y'all may recall that when we first started talking about changing the child support guidelines, it was stated that we needed this change because the judges were applying the guidelines too rigidly. They were never deviating from the presumptive award in the guidelines. Well, thankfully, the Child Support Commission actually did some research. They looked at 274 orders from 11 counties around Georgia, and they actually found that 41% of those orders, the judge actually deviated. So the problem we thought we were fixing with the child support guidelines turns out didn't really exist. I don't think we have the data. I know y'all have heard some statistics about how often courts award custody to moms or dads. I don't know where those statistics are coming from. But I think it'd be fabulous if this committee could do what the Child Support Guidelines Commission did, actually do some sampling for 1 month in Georgia. And I would encourage you to do what much of the research has done, and that is to segregate out those cases where custody is agreed to versus those where it is in dispute. Because what the research from other states has shown is that by doing that, you will get a truer sense of what the courts are actually awarding. Where parties actually agree on custody, they do agree that moms should have custody more often than dads. So you need to look at just those cases where custody is actually decided by a court to understand what's going on in Georgia. I also want to share with you some information about what other states are doing on this. It is true that there is some form of presumption of joint custody in other states, but the vast majority of them require the parents' agreement before that presumption is triggered. In other words, I'm guessing the reason they adopted this is to say that, look, if the parents themselves agree that joint custody is appropriate, we're not going to let the court override that, absent a specific showing that it's not in the child's best interest. That's a very different thing from some of the proposals that have been discussed before this committee, which would require a presumption in every case, regardless of whether or not the parents agree, and which would require a showing of unfitness to rebut it. Now, I'll tell you, I have not looked at every state statute. I'm plowing through them all right now. I have yet to find a single state statute that requires a showing of unfitness to rebut. And thanks to our wireless service here, after the first speaker spoke about Oklahoma, I actually pulled up the Oklahoma statute. It doesn't require unfitness. It says that if you show that joint custody would be detrimental to the child, then it can be rebutted. And I would submit, as a lawyer, detrimental is very different from unfit. So I just wanted to call that to y'all's attention. Another issue is that if we're going to be talking about creating any sort of presumption in the custody field, we ought to be creating a presumption against custody where there's been a finding of family violence. That's actually very common in the United States. 24 states have some kind of rebuttable presumption to say if a parent has committed family violence against another parent, we're going to presume it's not in the best interest of the child to be with that parent. And just to let you know, just in the southeast, Alabama, Arkansas, Florida, Louisiana, Mississippi, Tennessee, and Texas all have some form of a presumption against joint or sole custody for a parent who has been found to commit family violence. I want to say a quick word about legal presumptions. These aren't common in the law. I did a quick search of the Georgia Code just to put in the word presumption to see how often we already have a presumption. It's in cases where we pretty much know that the outcome is the right outcome for the state of Georgia. For example, there is in Code Section 16-2-3, it says a person of sound mind and discretion is presumed to intend the natural and probable consequences of his acts. So we're going to assume that if you're with it, if you're of sound mind, you presume the consequences of your acts. That's true in almost every case. Of course, it can be rebutted. I don't think the same can be said about joint custody. I think you heard Dr. McGarrett last time talk about how you can't have a cookie-cutter one-size-fits-all approach for all families. You can't presume that joint custody is the right result in every divorcing family. And I would submit to you that if you adopt a presumption, then you are going to shift the focus in the litigation away from what should happen for this family, and it'll be focused on what shouldn't happen. The party who doesn't want joint custody is going to approach the litigation with an eye towards, how can I prove to you that this shouldn't be the outcome? I believe that the focus of any family law case should be, let's look at the particular facts and circumstances of this family and figure out what should be the outcome, whether it's joint or not. I want to tell you just a couple of examples of cases that I have handled in which, unfortunately, the court did not find that there had been family violence, even in the face of incredible evidence that it existed. A woman came to me after having gone to court by herself. She didn't have the money for a lawyer to get a temporary protective order. Her husband had strangled her and threatened to kill her, and in fact was on probation for having killed his cousin when he was 16 years old. He had served a year at Alto and was still on probation. So this is someone who has a record of family violence against another family member. She had a 3-year-old and an 8-month-old. And even though the judge, which was in a metro area county, made a finding that he had committed family violence against her, the judge gave him custody of those 2 children. The judge And let me assure you, from what I know about this case, there was no allegation against Mom. There was no allegation she was not fit or that she shouldn't have custody of those kids. But this is a judge who was holding against this woman the fact that she had previously dismissed a TPO. She brought a TPO. He made her all kinds of promises. I'll do right if you'll just dismiss it. I promise I won't misbehave again. She took him at his word. And so when he was violent again and she came back to court, the judge said, nope. Once you've dismissed a TPO, essentially you can never come back to me with another one. So this is a case that should have been a slam dunk, that this man should not have had custody of those two kids given his demonstrated violence. But in fact, it happens in Georgia. One other case, I recently was in court where we had an audio recording of the husband screaming uncontrollably at the wife with the baby in her arms. You could hear the baby was crying, very upset by what was going on. He was making all kinds of threats against her. The judge refused to make a finding that family violence had occurred, even though everyone in that courtroom was chilled listening to what was happening on that tape. So I just want to let you know that for every case that you've heard about from some of the proponents of change, that they feel that they were wronged in the court system, I could provide for you just as many cases where I know my clients and other victims of domestic violence have not had the law applied fairly. I don't think that is the way we should be legislating based on isolated cases. I think it should be a matter of what, as a policymaking body, you believe is in the best interest of the kids of the state, and it should be based on some data regarding what's really happening in Georgia today. I know I'm out of time.
Yeah, you're out of time.
So I will. Could I just make one final?
One
okay.
more
There's been a lot of talk about lawyers who filed TPOs in the context of a divorce that are false TPOs. I will be the first one to stand with you in going after those lawyers, because as a domestic violence advocate and as someone who believes in the power of the TPO, I want to guard those TPOs for only those cases that are worthy. So I'd be delighted to work with you to try to figure out a way to preserve the option, but go after those unscrupulous lawyers. I'd file a bar complaint against them in a minute if I had them on the other side of the case, who are inappropriately trying to abuse the TPO process.
Other questions from Senator? Mr. Butler?
You answered my first question I had wrote down as you were speaking, which has to do with the fact that, should there be substantial penalties if you're making false charges, and you agree with that, and I do agree with that. And you stated in one of your examples that you had a case where you had proof of family violence and the award was given to the other parent. Isn't that what you said? Or what would you say?
What I said was the judge refused to make a finding that family violence had occurred. Our law provides that where a court has made such a finding, there are special protections that can be triggered. For example, supervised visitation can be ordered to protect the safety of the child and the parent. And that's what we were asking for. And so she declined to make a finding of family violence and declined to order supervised visitation.
Okay. Along those same lines, let's just have a, what if Georgia's law was different and there was a presumption of joint custody? How would that have changed the outcome of that?
Well, I'll tell you, I would have had to spend a whole lot more time in that this was a temporary hearing right after the divorce was filed, trying to show not only why supervised visitation was warranted, but why joint custody was not warranted. I'll tell you, that wasn't even on the table here because everybody agreed this guy had some issues. There was just a question of, did we think he should have supervised visitation or not? But that would have had to be a part of our case. We would have had to start off pointing the finger even more so at him if we wanted to make sure that presumption was going to be overcome, depending on the standard that was in place for rebutting the presumption.
Well, I mean, if it was that way, but yet if there was a provision including violence, would it have made a difference? I mean, I guess what I'm saying is, I hear what you're saying, and of course, I can tell you the truth, I really don't have an opinion on this thing either way at this point, because, like I said earlier, I mean, this is kind of like making a decision between two bad options, But I'm just trying to wrap my brain around, if there was a presumption, how would that change what you're doing in the case of family violence? I mean, if there's a provision in there that takes care of the fact that, say, if it were to happen, I'm just trying to see how it would change it, because I'm having a hard time. I get the argument, and I totally agree. Anybody that does that kind of thing, they shouldn't be around children, because of the fact that, generally speaking, what if they do something to the kids? However, I'm just trying to figure out, and I think you may have explained it right there to that point, that maybe you have to spend more time at the temporary hearing. Is that where you're more concerned about it, or I mean?
Well, at all hearings where that was an issue. I think at the last hearing, y'all heard a number of folks speak to that point, and that is, why can't we craft some sort of exception for domestic violence that would be broad enough to address our concerns? The reality is that no matter how broadly you craft it, there will be some victims who will not have the resources to make their case. For example, they won't have the resources to hire a lawyer. Just like this woman that I referred to previously, I can't say before that judge if the outcome would have been different if I had been there, although I'd like to think we at least would have made more of a record of his abuse. So if you don't have money to hire a lawyer, and 50% of the litigants in Fulton and DeKalb at least are estimated to be pro se, how are you going to demonstrate that there has been domestic violence in the past? Additionally, the FBI tells us that only 1 in 10 victims ever reports domestic violence. So you may not have a 911 call. You may not have a medical report. There's all kinds of really good reasons why some folks never tell anybody about what has happened. Additionally, even when they do, they oftentimes don't have injuries, so they aren't believed. You heard some reference at the last hearing to the Fatality Review Project that the Georgia Commission on Family Violence has done, along with the Georgia Coalition Against Domestic Violence, and y'all should have all gotten a copy of the report from last year. These are studies of homicides, so we know the woman was in danger because she was ultimately killed. In, I believe it was 58% of the cases in which there had been some prior report to law enforcement or to somebody, there was no evidence of any physical injuries. So it's quite possible the police come out, they say, well, you say he did something, but I don't see any marks on you, not charging him. I guess what I'm saying is, in a number of contexts, it's tough to really prove that that happened. It doesn't mean it didn't happen. So if we adopt a presumption that can only be rebutted by a certain level of proof, I think what it means is some folks aren't going to be able to meet that burden, and you're going to end up with joint custody in inappropriate cases where you're exposing kids to more violence.
I guess where I get confused is, I mean, you started off talking about the fact that in Georgia Code we already kind of had the situation that you're afraid we're going to have. Okay, well, I mean, you were talking about earlier the fact that there's some very clear language, very strong language that joint custody should be considered. I mean, so the argument you're making, if there was, this just argument you just made, aren't you currently having that situation right now? Don't you have situations right now where you have people who can't afford the right lawyers or whatnot to be able to prove this other person's unfit? I mean, everything you just said, it sounds like if these presumptions are there, then you're already having to do that. I mean, is that correct? I mean, already
yes,
or is it easier right now if there is a family violence to get custody awarded? I mean, I'm just trying to understand that part of the law, and I don't.
I ask you to make your comment brief because we had some other people
Sure.
who testify.
There is no presumption. The things that I spoke of earlier, that's what the law provides as options for the court. You can have sole, you can have joint, you can have sole physical, joint
legal. I'm talking
legal.
about in the case of domestic violence.
So yes, in cases of domestic violence today, we do have cases where we have a hard time saying, look, joint custody isn't appropriate. It would be harder if the starting point were joint custody. In other words, right now we're starting with just what's in the best interest of this child. Mom can argue this, dad can argue that, and the judge tries to make sense of it all. If you start off saying, as a matter of public policy, we think joint custody is right for every child, then you got to overcome that. That's how it would be made harder.
Any other questions? Thank you for coming today, Ms. Senator.
Thank you, Mr.
appreciate it. Thank you for your testimony. We're going to have to move quickly. We've got about 7 minutes or so per person to testify. Carl Johnson.
I guess I'm dealing with a truncated time schedule here. My name is Carl Johnson.
That's the problem.
My name is Carl Johnson. I'm the executive director of the Georgia Association for Marriage and Family Therapy. I've also been in practice as a marriage and family therapist for 34 years. I will say, by the way, that normally when I testify in the legislature, I first bring the issue to our board of directors, 25 senior family therapists from around the state. Our board doesn't meet again until November 3. I haven't had a chance to do that. I've consulted with my president, but what I'm saying is basically based on my experience as a family therapist and my knowledge of the literature. First of all, in the research, two factors over and over again rise to the top as the two factors which most consistently reduce harm and improve outcomes for children of divorce. Those factors are, number one, that the child is not divorced from either parent as a result of the parents divorcing each other. And number two, that the parents work together in a business-like way to make decisions regarding the child. Those two factors are the most powerful over and over again, and those are the factors that all family therapists work for in their work with families where there's divorce involved. And my comments here will be based on those assumptions. Now, as I understand shared parenting, which is what you're talking about, there are really three elements involved. And my sense of the confusion in a lot of the testimony here is because they're being glopped together. I think they need to be considered separately. As I understand it, shared parenting involves three elements. One, the presumption of joint legal custody. Two, the mandating of parenting plans. And three, presumption of joint physical custody. Two of those, as I see it as a family therapist, are beneficial, would be very beneficial for the families of this state, and one of them would be ill-advised. And I think they need to be looked at separately. Number one, presumption of joint legal custody. As I said before, one of the two most important factors is the parents working together in a business-like way to make decisions regarding the children. A presumption that the parents will have equal say in making the decision of the children forwards that goal. Secondly, we know that people marry who are not psychological similars. They're psychological complements. They come at things differently. You get balanced parenting when both parents are involved in the decision making. You get lopsided parenting when one parent consistently makes the decisions. So you're going to get balanced parenting with a presumption of joint legal custody. And thirdly, we know, I've seen in my practice over and over again, that when one parent is cut out of the decision making process, what ends up happening is that parent ultimately begins distancing from the child. They begin to feel they give up as they begin to feel they have no say in what goes on with the child. And so the other goal of the parent being divorced, the child being divorced from one parent as a result of the parents divorcing each other, that is also affected by this issue. So on all fronts, it seems to me advised that we work towards a presumption of joint legal custody, where the parents have equal say in making decisions regarding the children. Secondly, the mandating of parenting plans. More and more states are including that in their law. I would agree with what, and I don't know the name, but a woman family law attorney who testified at the last hearing said, maybe the most important thing the lawmakers in this state can do is to require parents to think through in advance how they're going to go about co-parenting their children. Requiring mandating a parenting plan would be extremely helpful, I think, here in Georgia. But then we get to the third factor, the presumption of joint physical custody. You're going to hear, we've heard, some folks say joint physical custody is the best thing since sliced bread. Some people think it's horrible. That's because every family is different. The circumstances regarding physical custody are different from one family to the next, from one set of parents to the next, under one financial circumstances, the parents' relationship with their children, their relationship with each other, geography, and even the age of the child. The physical custody arrangements need to change as the child changes in age. Joint physical custody is a terrible idea for very small children. It's very complicated to pull off. Some people do it well. It's tough to do. We don't even know, actually, we're beginning to learn what makes it work best and what doesn't. But a presumption of joint physical custody, given the very wide diversity of what this takes and what families bring to it, seems to me to be very imprudent. In fact, Representative Lindsay, you talked about, well, what if it was the 30 to 50 range in a previous hearing? You asked, what about that? I would venture a guess that maybe even with both functioning parents, maybe 50% maybe half of the parents could pull off maybe in that range, 30 to 50%. It's just too complicated, and it's too various from one family to the next for me to see a presumption.
My question is that I just want to sort of ask you to specifically address, if you could. The study or rather the collection of studies done by the American Psychological Association. What I was asking was, what was y'all's definition of shared custody? Because I understood the definition used by the American Psychological Association for shared custody was up to a 70-30 split. That was the point.
Okay.
Is that correct?
I'm not a psychologist, and I don't know what the American Psychological Association's definition is. I'm just saying that joint physical custody, which tends toward sharing equally the time, is complicated to pull off, and physical custody needs to vary from one family to the next depending on the circumstances of the family, the circumstances of the relationship with the parents with the children, the age of the children. Actually, if you mandate a parenting plan, you handle that because then the family works out some kind of a sliding scale arrangement depending from one family to the next, what works best. I know my time is getting short and I want to make a couple more comments. You talked about what should be the standard, and I'm not a lawyer so I don't know a lot about this, but the standard for presumption. And it seemed to me when I first thought of it that joint legal custody and mandating a parenting plan is such a good idea that should be mandated unless there's a finding of unfitness. That should be presumed unless there's a finding of unfitness. But then I heard something that one of the other people testifying, a male family law attorney, said in the previous hearing, and that was that when you make the standard unfitness versus the best interest of the child, you change the entire dynamic in the courtroom. That what people are shooting for suddenly becomes trying to prove each other bad instead of trying to look for what's good for the child. And that seems to carry a lot of wisdom to me. I think you would, in fact. And so even though I think mandating parenting plans and joint legal custody are extremely good ideas, I personally think that keeping the best interest of the child, you want to have somebody else said they want to have a consistent standard throughout, and if you're going to have any consistent standard throughout, it needs to be the best interest of the child. And my final comment is, I hear there's some issue in here about at least in the handout you gave, about guardian ad litems and forensic mental health evaluators not being involved absent a pleading of parental unfitness. I can't imagine for the life of me why someone would want to tie the hands of the judge in that way. It is axiomatic in mental health field that you make the best decisions when your information is the most complete and most accurate. And I would think that you'd want to always have the judge have the freedom in the best interest of the child to get a guardian ad litem involved or to get an evaluation. And I would say that the members of my association, Marriage and Family Therapists, almost none of them do custody evaluations, and almost none of them serve as guardian ad litems. The psychologists do the custody evaluations. So we don't have a financial interest or a professional interest in it. I just think that you wouldn't want to tie the judge's hands in that way.
I thank you for your testimony, Mr. Johnson. That's some new ground there. Any questions other than Mr. Lindsay's question, Mr. Johnson?
Just one, based on your experience, what percentage of the cases that you see is a joint physical custody workable? And you can even go below a certain percentage.
Well, first of all, remember the folks who come to me because things aren't working well.
Yeah.
So I see a biased sample. And I've got one family I'm working with now where there's a 50-50. The kids spend 1 week, every other week, with one parent or the other. And those folks are working hard at doing it well. It's extremely tough to pull off. One of the things I see sometimes is where there isn't somewhere where the buck stops. The buck stops here, where somebody doesn't have ultimate authority. I mean, it's not ultimate authority because I agree with joint legal custody, but where the kid is moving back and forth, sometimes it's easy for stuff to fall between the cracks. It's easy for things to get lost. Issues don't somehow become clear. It seems to me it's very tough to pull off. You really have to have a situation in that where the parents are very good at collaborating. But I do think it is important, again, for the children not to be divorced from either parent as a result of the divorce of the parents.
Thank you, Mr. Johnson. We appreciate it.
Thank you for the opportunity to speak.
You're welcome. We're going to conclude this with Miss Peggy Walker. I couldn't read my own writing. I'm sorry. Judge, we're welcome today. Thank you.
Good afternoon, and thank you for the opportunity to join you this afternoon. I'm Peggy Walker. I'm the judge of the Juvenile Court in Douglas County. I have a master's in education and a child development background. I have my Juris Doctorate degree and also certified as a mediator. I spent 20 years doing custody cases as an attorney, a guardian ad litem, and now as a judge. I work as a 0 to 3 fellow with expertise in children under the age of 3, and I've been appointed to the Family Violence Commission because of my expertise in children who live in family violence. I want to throw out a couple of ideas to you. The first thing that I want to mention is if you're going to create legislation on shared parenting, we need parenting coordinators, because there comes a time when there's conflict between people, and the children often are the ones who end up having to settle the dispute, being caught in the middle. And parent coordinators is at least an option, a form of mediation that can be used to take the child out of the middle. The second thing that I would ask you to do...
For a second, I'm sorry, I haven't done this before, but I just
Sure.
wanted to make sure we get it while we're there. A parenting coordinator is a position that's already in place?
No, it does not exist in this state.
Okay. All right.
But if you're going to have parenting plans, and then there will be disputes as to what those plans mean, inevitably those things happen, you can have a form of mediation through this parent coordinator.
So this is short of a guardian ad litem situation?
Correct.
Okay. Thank you. Continue.
Another thing that I would suggest to you is 2 exemptions if you're going to have a presumption. Please exempt high conflict cases, and please exempt family violence cases. And let me explain to you why. The irony of coming today is that I am in round 3 of a high conflict case. 8 years ago, I did the initial divorce custody case, and I ordered joint custody because I had 2 extremely well-fit parents, highly educated, very affluent people, very fine citizens. I did a 4-3 split. It did not work. They came back for round 2, and this time I did a different split. I did the daughter to the mother and the son to the father, with them spending evenings together during the week, and with them the children being together each weekend. That has failed, and they are back for round 3. And these are people who should be able to do shared parenting, but they hate each other so much that they cannot do it. And the end result is the daughter has a problem with mental health now. That's not solely from the divorce, but it is made worse by the divorce and by the conflict. So I would encourage you to please exempt high conflict cases. The next thing is to talk about family violence. You cannot have shared parenting in family violence because there is an imbalance of power, and the children will be used as a tool to control the spouse who has been abused. Now, a spouse who has been abused more often than not is a woman, but men can also be the victims of family violence, and I certainly have witnessed that on many occasions. I want to tell you that family violence in this state is very, very serious. We rank 7th in fatalities from family violence based on the 2004 data. And I'm very disheartened by that because I've worked on cases where these murders have occurred. And I'm also the one who hears those family violence cases, makes those custody determinations, and then I'll go home at night, pick up the phone, and ask the police to go out and do a welfare check, because this confrontational system that we have stirs up such strong emotions that I'm afraid that that person is going to be dead before morning because of all the ugly things that have been said in court. So it's very, very scary business that we're in when we're making these kinds of decisions. Please understand that when someone perpetrates family violence, there's a 40% likelihood that now that the spouse is out of the way, the child may become the person who gets battered. This does happen, and I've seen it happen. I also want to you to understand that I think that we have to give people an opportunity to change, and we have to give them resources to change, and we certainly want to give children access to parents. But I'm just saying, be very careful in what you do, because if you've ever worked a situation where someone's been murdered, you have no idea what trauma it is. And that, unfortunately, has occurred for me with 3 different victims. Other factors where shared parenting is not going to be appropriate. Substance abuse. You really don't want to put children in a shared custody arrangement where you have a substance abusing parent. Mental illness. Some of our parents, even though they know they're diagnosed with mental illness and know that if they take their meds they'd be fine, they won't take their meds because that makes them feel differently. And they are very poor parents when they don't take their meds. Frequently we have developmentally disabled parents, developmentally disabled children, and it's very difficult on them to be in these types of situations. We have medically fragile children, and we have other special needs that have to be addressed. So just saying that everybody should do this will not work. Now, I believe that shared custody benefits children, so please understand that. These children typically will be better adjusted, they'll be more successful because they have positive relationships with both of their parents and with families. Because when we set up this thing of having very limited contact with a parent, that means very limited contact with their extended family as well. That's really not good for children. What we're really talking about is access, and we really do need plenty of access for children to their families. Shared custody works well when parents love their children more than they hate each other, when they live close together, when they have similar lifestyles and similar values, and when they have similar rules and similar discipline. It requires the development of a business relationship. When the man got up here and talked about the email and he types it and then he strips out all the ugly stuff, that's what I'm talking about. And I have to put in my orders, you will establish a business relationship, and if you don't, I'm going to jail you for every day that you do it. And finally, I've had to actually put people in jail for every time they've called the parent an ugly name in front of the children, because the emotional abuse that it does to children, the emotional harm, is absolutely tremendous. Children are a product of both parents. When you say something bad about the parent, the child incorporates that as being something bad about themselves, and that's why it does so much harm. It also requires recognition that the marital relationship is over. It requires communication skills. It requires flexibility. And for children, what we need is predictability. I cannot imagine going to a different home every single night. I cannot imagine how many years and how much it takes to overcome that. Sole custody, the big problem is having the concept of an absent parent versus a caring parent. A person who doesn't have custody doesn't mean that they don't love their child and they don't care for their child. Not at all. And having the concept of the fun parent versus the disciplinarian parent. When you don't have much time with your child, then yes, there is a propensity to try to do things that are great and wonderful to make it memorable. But that's not what life is. Life isn't all fun. Somebody's got to do the work. Risk factors for children are huge. I want you to understand from the juvenile court perspective, the four things that trigger alarms for me in families are when I'm dealing with a single parent household. So that's why access to both parents is really important, because children are more vulnerable when they live in a single parent household, when they have an incarcerated parent, when they have a substance abusing parent, when they live in poverty. Those are the greatest risk factors and the things that bring people into our court. Now, the rest of my presentation are comments. We have a sidebar where judges can talk with one another. I told them I was coming here. What would they like to share with you? And I'm just going to flip through those comments and make them very briefly. What the first comment is that what it amounted to was the child had a suitcase traveling between two bedrooms with neither place being home. But the judge also said, I favor heavily involvement by both parents. The second comment raised the same issue I've already raised. You really don't want this to apply if you're dealing with a drug-addicted, insane, or abusive parent. The next comment, and this is critically important to understand, people who can do shared parenting will reach agreements, and those cases will not be contested. Mothers and fathers capable of shared parenting do not divorce. Shared parenting can easily be subverted by a parent to the disadvantage of the children. It's a good option for good parents, but it can also deny stability to children by being commuters between homes. Another comment. This is another way of introducing the concept of shared parenting adjustment that was removed from the worksheet calculations under the new child support guidelines. Another comment, it sounds like adults wanting a further recognition of property rights in children, an altogether bad idea. The next one, the realities of life are such that rarely is shared parenting a viable method of raising children, especially when parents do not get along. Shared parenting is a notion that satisfies the needs of the adults but rarely meets the needs of the child. We, as the judges of juvenile courts, often see the results of children who are able to play their parents or are caught between the fights of their parents. They end up in our court. Co-parenting is not a bad idea. Parents either get over it and get on with it, but clear guidelines as to the duties of the custodial parent in sending schoolwork, notice of activities, appointments, and providing extended visitation where appropriate works. Psychologists in deprivation and domestic cases say children can survive trauma if they do not have to relive it. Legislating ex-spouses to be good parents opens up the battlefield, placing the child in the middle. He goes and gives an example of what happened in one of his cases, and goes on to say that quality separate time with each parent is sane and allows a relationship with each parent. A new law will not make parents play nice. An alternative is offered in Utah's presumption of extended weekends if it's in the child's best interest. And basically, my concluding remarks are this. Legislation alone in this area will not benefit children. We do need better training for judges, training for parents, training for attorneys and guardian ad litems, to make sure that every child has adequate access to their parents. Access and use of parent coordinators will certainly facilitate resolution of conflicts in shared parenting, and there's tax incentives in the United Kingdom to encourage people to do shared custody, where both parents can claim a personal tax exemption to be able to have a shared custody arrangement. Thank you very much for your time, and I'll certainly answer any questions.
Thank you, Judge Walker. Any questions for Judge Walker? Yes, Mr. Lindsay.
If I may, Judge, thank you for coming. We've had a lot of talk about joint legal custody. I just want to pick your brain on this. How does that work in terms of someone ultimately has to make the call?
Yes.
Tell us, when you talk about, somebody said, well, we should have a presumption of joint legal custody. I want to know how that's going to work in the real world. What's it going to look like?
You have to have specificity in your orders. And because I started out working for a judge and then worked as an attorney, I know how to do an order specifically. So I go into those particular categories. And I will say that in education, both of the parents are going to be present, and if they can't resolve it, who's going to make the decision? I will determine who's going to make the decision regarding religion, who will make a decision regarding medical care, who will make a decision regarding extracurricular activities. And in a joint legal custody situation, I may well split it out between the parents. The person who provides the insurance is usually the person that I'm going to have making the medical decisions for the child, unless they're not available and then the other parent will. But I'm very specific in my orders, and I think that that's what is lacking in our present system. We use the terms are very loosely defined, and then nobody really knows what it means, and it gets interpreted in every which way.
Do you have a sort of a standard definition that you use in your orders? Am I hearing that from you?
Yeah, I would say there's fairly standard language that I use.
Could you provide that to us? Let's take a look at it. It might help us.
Sure, I'd be happy to give you some examples of what I've ordered.
Does that mean you want to have a question?
No, I've heard Katie before.
Shake your head some other direction then. Well, thank you, Ms. Walker. We appreciate you coming today and sharing your insights and your experience from the bench on this. We appreciate it. Thank you.
And I'll be happy to tell you that I'm in Douglas County where the remark was made about the calf. Judge Nolan is dead, and so is that concept, I'm proud to say.
Thank you for that anecdotal comment. We've probably already eaten the calf along the way, too, so, Well, look, we're going to stop here, and my apologies to anybody who did not have an opportunity to testify, although I've been kind of keeping track in terms of the time split and the comment split, and frankly, it's turned out to be pretty much equal along the way here, and so between all the three sessions. So I really appreciate the fact that you really have worked hard to try and alert us to the difficulties of this issue. and the opportunities of this issue. And so we're going to, the rest of the process will be to sift through all the comments that have been made thus far. And then among ourselves, we're going to try to come to see what type of agreement we five have on this. And then we'll issue a report, and that report will be available before the session begins in January. Generally, that takes the form of a late December type of a set of study committee recommendations. We reserve the right to, if you're willing, to call people back in to give us additional insights as we may feel like we need them. But for the public hearing portion of this process, we are really gratified by the fact that you've taken time to come to here and give us your views on this in such a good, well-founded manner. So thank you for coming, and we're adjourned.